Hi, everyone. So, I was on earlier to talk about DNA, and Annie Potts had said something quite interesting. And wouldn't you know it? What if? Because we do know that Eliza Massath had mentioned Frank's material. Now, I wanted to explain what Frank's material is, and then I want to get into what Eliza Massath said in accordance to the Frank's material, and Miss Annie Potts' theory. So let's see. So, like I said before, sometimes these attorney websites can have pretty good articles on them. And this one in particular, these guys are called Bradley and Friedman. And so they're going to define for us what is a Frank's hearing. In some criminal cases, the defendant may believe that a police officer has falsified information to obtain a search warrant. And in such situations, it becomes imperative to have an experienced criminal attorney by your side who can navigate this critical legal landscape. And so a Frank's hearing is a crucial court proceeding where the court is asked to examine if the police officer involved provided false information. And a Frank's hearing is also known as what you would call traverse the warrant. Traverse is like another word for travel. You're traveling through the warrant because the defendant wants to walk the court through the warrant so they can show the court that the police officer made false statements in the affidavits to secure the search warrant. And this type of hearing gets its name from the landmark case, Franks v. Delaware, which established the defendant's right to challenge the truthfulness of facts stated in a warrant affidavit. The objective of this hearing is to ensure the integrity of the criminal justice system by holding law enforcement accountable for their actions. If a defendant can prove that false statements were knowingly or recklessly included in a warrant affidavit, it could potentially lead to the exclusion of evidence obtained through that warrant. So, we did hear Eliza Mathis say something about their motions to suppress are coming. Motions to suppress are coming. And she wouldn't say motions to suppress are coming or drop Frank's material unless she already knows. She's already found a false statement. And according to Miss Annie Potts, well, we all watched that clip. I think it was it on Golf Inspector and Lana Truth and Transparency, where Eliza said it has to do with the most critical piece of evidence in the affidavit, probable cause affidavit, which Miss Annie Potts, rightly so, says that's the DNA. The DNA. Did Brett Payne lie about the DNA? Now, for me, maybe it is the DNA because Cy-Ray he's already stated in court, uncontested, that Brett Payne did not use the required documentation. And he said he needs the source material, not just him. any expert that is going to look at this information and verify the accuracy of the alleged route in one of Brett Payne's affidavits, or the probable cause affidavit, they need source data. And he's like, not just me, any expert needs the source data to see what happened here. So if the source data is missing from what is needed to verify the accuracy of a route, that means that that could also be Frank's material. And it's just, what if there's Frank's material on the cell phone and the DNA? Because the DNA is pretty mysterious. For one, ISP didn't find anything, so then they sent it elsewhere, and then they found something. But that something didn't identify anyone. They created it sounds like Ortham Labs created a SNP. In the state's own motions, it says Ortham Labs created a partial tree. A partial tree doesn't lead to any one person or any one family. So I do believe the IgG is incomplete. So if the IgG is incomplete, it's the false statement that the DNA matched to Brian Kohberger. Because also, who was it? Was it Heather Fitzgerald? Somebody else was in here and said that inside the cell, that book or that article was included in Bicca Barlow's declaration because the IgG has nothing to do with Brian Kohberger. Wouldn't that be something if Brett Payne lied about the DNA in this case? I think the more that we are finding out about what's going on, that the state, what they needed to do in this objection to the change of venue is they needed to put in there their support to state, yeah, what we stated in what Brett Payne stated in the affidavit, according to what the records he saw from the FBI agent Nick Valance, placed the cell phone somewhere, but they didn't. They just said in the vicinity of its cell phone tower. A vicinity of a cell phone tower is very vague. It's not scientific. You can plainly just guess everybody in the town and the town next to it, everybody was near the vicinity of a cell tower. So that right there, we've already known that there's probably a false statement there too. But what about this other piece of it where, because Cy Ray already has that information. He's already mapped it. He already knows it's wrong. It was Ann Taylor trying to demonstrate for the public, for the court, that the second AT&T warrant was obtained with false information or information that was excluded, which is the source data. You can't allege what you're alleging without the source data. But Eliza Masseth is also looking for these, what were they, federal warrants? Or and she needs one in particular because the timeline is very important. They need to know when the state knew what and when. And if that's the case, they need to know if there's also a false statement. So is there two pieces here? Because we already know the cell phone stuff is false. Ann Taylor and Syrie demonstrated that. But Eliza Mathis also said they are still looking for documents because there is a false statement or there's a date that could be wrong, and it has to do with the most crucial piece of evidence in the PCA, which is the DNA. Now, before it could have been like crazy to think, and people would criticize you to say, well, maybe there wasn't an investigation done here. Maybe the police, law enforcement, they knew what happened within 12 hours. And in order, like J. Rod on Point was saying earlier, the university couldn't have law enforcement investigating the victims because that would reveal that the students at the school are responsible, which would mean in a roundabout way the university is responsible too. So they're trying to shield all that, and we all know something's wrong here. But either way, if there is something wrong with the most crucial piece of evidence in the PCA, the DNA, is that possible Brett Payne made a false statement about that DNA matching? Well, I think there is already enough evidence or court information, not information from mainstream media, not information from all of these people who are emotionally invested for Brian to be guilty, but the court information. Becca Barlow has already said it's an ambiguous partial profile and that the IGG has nothing to do with Brian. By the state's own motion for protection order of the IGG, the FBI did not compare the snip from the snap of the button on the knife sheath to the defendant's snip. So the FBI did not identify Brian. Wortham Labs did not identify Brian. So how did they get to him if there's no DNA here? So there will be, most likely will be a Frank's motion. Now, here are the list for the grounds for a Frank's motion. A Frank's motion is not automatically granted. The defendant must first make a preliminary showing that 1. The affiant, which would be Brett Payne, knowingly and intentionally or with reckless disregard for the truth included a false statement in the warrant affidavit. 2. The allegedly false statements was necessary to find probable cause. Yeah. Because if you don't have the DNA or the cell phone information, there is no probable cause here. And the way that things are unfolding, there's already documentation in the motion to compel hearings, the 4th and 5th, that the required information was not relied upon. So Brett Payne cannot make those statements without the information that the defense is asking for. That's why there are motion to compel hearings. And with this, with this other part of it, that there's an issue with the most crucial piece of evidence in the probable cause affidavit, also points to how many false statements are there here in this case. What did Brett Payne do? And again, I was saying on the last live earlier today that the mainstream media has a role, has a relationship to this case. They have a specific role, and they've, for the most part, been pretty good at that. However, there are people out here like all of you, like me, and we can see beyond that because things don't make sense, and things don't make sense because there are false statements. As it comes to light that even more so than it already is, that the state did not do what it was supposed to do. we'll have a clearer understanding of these false statements that Brett Payne has made. And like Eliza said, motions to suppress are coming, and she made it seem like there are many. There are many, which means I do believe motions to suppress are coming, and Frank's motions are coming for at least the DNA and the cell phone data. And if you saw the video I posted, I don't know when it was, but it was of Ann Taylor at the end of, I think, one of the motion to compel hearing. She was going over the things that she has yet to receive and the things that she has received. And she was going over, I think it was 4 numbered items, which she said that they were specifically related to identification of a vehicle, and the vehicle in question was a 2011 to 2013 Elantra. So why is the state handing over video of a 2011 to 2013 Elantra? When in the PCA, it says, yeah, the FBI originally said those years, but then he expanded it to include Brian's year. Let me see if I can pull it up, because that is really, it's really something. Let's see. Oh, this is it. Oh, hello! Reluma One, welcome. Okay, so I'm going to play this for you. Listen carefully, because the state gave the defense video of 2011 to 2013. That's odd.
So when, and I will emphasize, when all of the data is mapped, and I'm talking about the CDRs, we can get a really good idea. Hey, a phone traveled north for 10 miles and then it traveled east. The drive test data would actually allow us to replicate and recreate these tower handoffs that we're seeing to come up with that first theory. To now we can say, in order to do this and hit these towers in the sequence that it did, it has to be driving on this highway. And then when it went east, it most likely turned onto this highway. So the drive test data helps us get very specific with what the CDRs mean.
As an investigator in performing an analysis work done in this case, when you have the CDRs, the call detail records that tell you where a phone's been, is that useful in directing your investigation to what other evidence might be out there, like videotapes?
I have to qualify my answer to it because I'm not sure if you're asking specifically for this case or in general. Yes, you map all of the data. And especially if you're going to justify 6 months worth of data on somebody's cell phone, you map every single connection that there is in those records. From what I have reviewed, the FBI mapped 6% of the data that came in. Mallory's testimony and what I've seen through here, he was up to about 18%. So by either standard, more than 80% on both accounts were never mapped or accounted for. And I'm not talking overall from every single day for 6 months. I'm talking about the timeframes that are chosen. So for example, this time period that's represented here is where I'm getting the 18%.
And that's the 48 hours?
This is specifically from 2 a.m. to 6 a.m. on the morning of the 13th, arguably the most critical time period of this entire investigation.
And now moving on to request 317, 322, 319, 320, 321, 323, 320, and 324. And then picking back up with 302. Those are all
8
surveillance camera items that we've requested. We're asking the court to order
on the alleged route
Moscow
that
Police
Payne
Department as the
alleges in the
custodian of
PCA.
these things in this case to do
They
an
need
inventory
those
of
to
what's there.
prove what Brett
You
Brain is
heard
saying. don't
Last
have
week that
them.
Detective Mallory said, I don't have the videos, those aren't my responsibility. You heard today Detective Payne said it's Mallory and FBI agents. So we take Mallory out of the equation. He said, I didn't do it. I can't tell you where these videos are. I don't know who the FBI agents are. So first, I think the court ought to order that that be disclosed to me. The second offer was that I can go to the Moscow Police Department evidence room and go through hundreds of hours, thousands of hours of videotapes, and that's just not reasonable. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road south of Moscow on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Brian, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are. They were collected. The court can see that from the reports that we put in the packet of evidence. The court knows they've been collected.
Miss
But nobody
Pottage,
can tell me where.
welcome.
And I need to have I don't physically have time to go watch thousands of hours in
Good to
Moscow
see
Police Department and
you.
be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and get that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas.
2013
That's just critical.
coming
and
up
that
in
needs
just
to
a
happen.
second.
The rest of them, 335,
Here they are.
336, 337, 338, and 339.
Five videos.
The state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 Elantra. They say we have it all. So if we have it all, that's great. I just don't want any surprises.
So
again, Your Honor, and we think the court should order the things as we outline. They're material to the preparation of our defense. I would remind the court that relevance is the standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. That was talked about in the Pendleton case, and I know the court's familiar with the Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit.
So there were 5 exhibits there.
New details about yesterday's quake
that are of, I think she said one video, but the car in question is a 2011 to 13. Why in the world is the state giving the defense the 2011 to 2013 Elantra when they were saying that the car is Brian's car, not this 2011 right here. So these are all, I think, different angles of a video. You got 1, 2, 3, 4, 5, and they're all of a 2000 to 2011, 2013. That's odd. But it goes along with the same vein that we've been listening about, is that there isn't evidence in this case to support it. And there is something wrong with the most crucial evidence in the PCA, which is probably the DNA. And so I just wanted to go over that and to make sure that people understand the mainstream media does have their role in this case, and it's to distract from what's actually going on in the courtroom. What's going on in the courtroom is odd. And usually when things are odd, that means there's a false statement. And that's exactly what Eliza Mathis, she says the motions to suppress are coming. So I think we all intuitively knew something was wrong with this case. What if we all intuitively knew there's a lie or more than one lie, and that this is why it doesn't make sense? Something's wrong here, and I know we feel it. So I think the mainstream media is going to get worse, and I think these damage control agents are going to get worse as this case starts to fall apart. The more that comes out about it, the more we realize the state did not do its job. And when the state doesn't do their job and evidence doesn't exist because what they're saying never happened, that usually means there's an innocent person in jail. So I hope people are paying attention and they saw this at the bottom of the state's motion to the defendant's motion to change venue. At the bottom here that says the probable cause affidavit did not explicitly state the defendant was near the actual home of the victims, but stated the defendant was in the vicinity of a cell tower servicing the area of the victim's residence 12 times in the months before the homicides. That's telling, because right here, they should have inserted the support they have for that statement, which would be the CDRs or the cast draft report or something that is scientific that will tell you the general vicinity of the defendant and what you're alleging is true. They failed to do that here because they don't have it. I mean, you would put it in there if you had it. And also, I don't know if you guys follow Andrea Burkhart. She's great. She's an attorney. She's been following this case. And she says here, the PCA's description of investigating whether Brian stalked the victims and discovering the pings to the tower servicing King Road is exactly why people believe to this day that he stalked them and returned to the home the morning of the killings. Now they want to walk that back. And again, that is coming from an attorney. And she also says down here, it's self-evident that they considered the pings to be circumstantial evidence of a victim-focused behavior. There is no other point for including it in the PCA if, as they are now suggesting, it is just a non sequitur that everyone reading the PCA misunderstood. There's a motive behind that, and that was to establish the relationship with the mainstream media, because the mainstream media, their role is to fill in the gaps where Brett Payne couldn't, because there is no existing evidence, and they are meant to distract. So I wanted to put that out there. If you don't know Andrea, and Andrea also, she has videos about the outcome of this change of venue hearing. And I've heard people out there who are a little confused. If the judge does grant this change of venue hearing, he gets to choose whether he goes or not. Now, if you follow the Lori Daybell case, her trial was moved over to Ada County in Boise from, was it Rexburg, Idaho? And the judge on that case did not go. The judge said, okay, we're going to do a change of venue, but I am not following with the case. So that does happen. It will be an option. I hope it is an option. because I think that that'll make a lot of difference in this case. If not worse, I can't forget Eliza Mathis saying that Frank's motions are coming. That's huge. Like you don't mention Frank's motions unless there's something serious going on. And Eliza would not have said that if she doesn't already know there is a false statement. And this is going to get really interesting. I just wanted to put that out there that maybe there's a false statement regarding the DNA. In addition to the cell phone stuff. So, and then I just wanted to go over this again. A Frank's hearing is a crucial court proceeding where the court is asked to examine if the police officer involved provided false information to secure a search warrant. Anyway, I just wanted to get up on here again to say hello to everybody. And I just want to say that I will be visiting Excited Utterance tonight at 9 p.m. Eastern Standard Time. And Twitter's favorite, Kathy from the Commercial Zone, she will be on it. And I look forward to seeing you all there. It should be a good time. Thank you all for stopping by, and I'll leave your comments in the comment section. I'll see you next time. Bye.